Hey everyone, in this series of videos I'm going to talk about breach of contract. Because breach of contract is such a broad area, there's so many things involved. I've got to divide this video into series, into different parts. So this is an introductory video. I'm going to talk about the basic aspects of breach of contract. So before we actually go into breach of contract, we need to know the kind of terms in the contract. Contractual terms can be classified into three categories: conditions, warranties, or innominate terms. Some breaches of contract allows a person to, the innocent party, to claim damages, but he cannot terminate the contract. He cannot cancel the contract. The contract still goes on. Other kind of breaches allows the innocent party to terminate the contract. So I'm going to go into the first type of contractual term, which is called conditions. Conditions are very important terms that must be performed by a party to the contract. If one party fails to perform a condition, a very important term, the other party has the right to cancel the contract, to terminate the contract. And in addition, he can sue for damages. Let me give you an example. You send a Rolex to the Rolex Center for repair and servicing. So therefore, a contract arises between you and Rolex Center for the repair and servicing of the contract. It is a condition of this contract, okay, an implied condition, that the parts used for the repair are genuine Rolex parts. So if they use parts that are not genuine, made in China, it is a breach of the implied condition that genuine Rolex parts will be used. This will allow you to immediately terminate the contract and also sue Rolex for damages. Now I'm going to go into the next kind of contractual term. These are called warranties. Now, contract warranties are different from the kind of warranties you see for electronic equipment. You know, when you buy mobile phones or TVs and other electronic equipment, you usually get a 1 or 2 year warranty. Now, these warranties in contract law are different. In contract law, warranties are terms in the contract that when breached, the innocent party can sue the defaulting party for damages arising from the breach. But he cannot terminate the contract. The contract has to go on. He can only claim damages for the breach of a minor, not so important term. If an innocent party terminates a contract because of a breach of a warranty, then he may find himself liable for unjustified contract termination, because the contractual term is not very important. It does not justify, give him the right to terminate the contract. Let me give you an example. You buy a Mercedes. There is an implied condition that the engine of the Mercedes is working perfectly well. Okay, if the engine of the Mercedes is not working well, then you are deprived of substantially the whole benefit of the Mercedes. Then there would be an implied warranty that the upholstery, the leather in the car, would be in good condition. So you enter into an agreement with Mercedes to buy a Mercedes-Benz. And then after delivery of the car, you find that the leather on the seat is a bit cracked, or there's a bit of discoloration. So that would be a breach of a warranty that the upholstery is in good condition. So this does not entitle you, this small little defect, the discolored upholstery or the crack in the leather, it does not allow you to terminate the contract to buy the Mercedes. Okay, you may sue for damages, but it does not allow you to terminate the contract. Next thing I'm going to talk about is innominate terms. Innominate terms refer to contractual terms that lie in between conditions and warranties. Okay, whether or not an innominate term, a breach of an innominate term will allow the innocent party to terminate the contract depends on whether the breach of the innominate term is such that it deprives the innocent party of substantially the whole benefit of the contract. If the breach of an innominate term deprives the innocent party of substantially the whole benefit of the contract, then he will have the right to terminate and sue for damages. Otherwise, if the innominate term is not so serious, not so important, he will only have the right to sue for damages but not terminate the contract. The contract has to still continue. So, how do the courts decide whether terms in a contract are conditions of warranty? Well, sometimes it's expressly stated in statutes. That means laws passed by the parliament. For example, the Sale of Goods Act. The Sale of Goods Act provides that certain sale and purchase terms are to be implied conditions while other are implied warranties. For example, in a contract of sale for goods, there is an implied condition that the seller has the right to sell the goods. He has the title, the ability to sell. It is a condition. If he doesn't have the right to sell, there is a breach. The buyer can terminate the contract. Let me talk about implied warranties under the Sale of Goods Act. An implied warranty would be that the goods sold are free from any charge or encumbrance. Charge or encumbrance means a lien. That means someone else has a right over it because it is held as a security or collateral. For example, in a contract for the sale of Wagyu beef, and the description is that the Wagyu beef is grade A5. There is an implied condition that the goods, the product, the beef will correspond with the description. So, for a contract for the sale of A5 Wagyu beef, if the buyer takes delivery of the beef and then discovers that the beef is actually grade A3 or A4, which is different from the description, it does not correspond with the description, he has the right to terminate the contract and then sue for damages because it's an implied condition under the Sale of Goods Act. Another example of an implied condition under the Sale of Goods Act would be a contract for sale by sample. So if the seller gives a sample, for example, 1,000 thread count Egyptian cotton cloth, okay? He gives a sample to the buyer looks at it, feels it, okay, he says, okay, I would like 100 bales, 100 boxes of this 1,000 thread count Egyptian cotton. And then subsequently, the Egyptian cotton cloth is delivered to the buyer, and then he finds out, after examining it, it's only 800 thread count. And it's not Egyptian cotton, it's some kind of cheap cotton. So there is a breach of an implied condition. So he has the right to terminate the contract and sue for damages. Another factor that the court will look at is the intention of the parties. The court will look at the intention of the parties to see whether they regard the term as so important that it would be a condition of the contract such that if the term is breached, one party will be deprived of substantially the whole benefit of the contract. The third factor that the courts will look at would be industry practice. For example, in a contract for the delivery of perishable goods such as milk, meat, vegetables, it is an implied condition that time is of the essence. Why is it so? Because it is very important. These goods are perishable. They will spoil very quickly if they are not delivered on time. So it is a very important term for contracts, for the delivery of goods, okay? of perishable goods, that they be delivered on time. If they are not delivered on time, the customer can terminate the contract and then sue the delivery company for damages. So this is all I have to say about contractual terms. Stay tuned for the rest of the other videos on breach of contract. Thanks for watching this video.